Hi there. Thanks for tuning into the Freedom Update. I'm Christine Van Gyn with the Canadian Constitution Foundation, and today I want to talk to you about the Charter at 40 years old. If you're new here, welcome. My name is Christine Van Gyn, and I'm the Litigation Director for the Canadian Constitution Foundation, a Canadian legal charity that fights for fundamental freedoms in Canada in the courts of law and public opinion. As a little bit of a constitutional law 101, the Charter sets out the rights and freedoms that are necessary in a free and democratic society. If you've never read the Charter, you really should. You won't be able to protect and defend your rights if you don't understand them or know what they are. And at the Canadian Constitution Foundation, we actually have a free online course that you can take about our fundamental freedoms. You can sign up at theccf.ca/learn. Charter sets out a number of rights, like, for example, the right to free expression, freedom of assembly, freedom of association, freedom of religion. It sets out our democratic rights, like around elections and voting. It sets out your rights on arrest, detention, or search. It sets out your right to life, liberty, and security of person, your mobility rights, the right to enter, remain in, and leave Canada, your right to a speedy trial, and our right to equal treatment under the law, among others. Now, the Charter is a part of our Constitution, the laws containing the basic rules of how Canada operates. And the Constitution is the supreme law of Canada, and all other laws must be consistent with the rules set out in the Constitution. If they aren't consistent with the Constitution, they aren't valid law. Now, as I'm sure many of you know, our rights guaranteed under the Charter are not absolute. They can be limited under Section 1 of the Charter if that limit is demonstrably justified in a free and democratic society. And what that means, the test for when a limit is justified, it's called the Oakes test, and it was developed by the courts. I have called repeatedly for the need for a stronger civil liberties culture in Canada. That starts with public education, as well as support for civil society organizations like the Canadian Constitution Foundation. So talk to your friends and neighbors about the need for a protection of our fundamental freedoms. You can also stay up to date with all the ways that we at the CCF are fighting for fundamental freedoms by signing up for our Freedom Update emails at theccf.ca/freedom update. And of course, by subscribing to this YouTube channel and ringing that notification bell so you never miss one of these updates.
Thanks for tuning in. My name is David Fraser, and I'm a privacy lawyer with the Canadian law firm Megan Cooper. I spend a lot of time watching videos on YouTube, and given my interest in law, photography, videography, and drones, my recommendations sometimes include videos of what are often called freedom of expression auditors, or in the US, First Amendment auditors. You may not be familiar with this type of activity, so let me describe it. Essentially, the practice is ostensibly done by people to determine whether their rights to photograph or video record in public places will be respected. First Amendment audits involve people filming in public places, often in government buildings, to test their right to record in public. So if no confrontation or attempt to stop the filming occurs, then the facility passes the audit. If an employee or a police officer attempts to stop them filming the event, it fails the audit. Auditors believe that what they do promotes government transparency, but critics find it confrontational and potentially harassing. While I think this originated in the US, this practice has spread to other countries, including Canada. Auditors often film in public spaces, like sidewalks or post offices, and it will often lead to conflicts with property owners who try to restrict the photography. Now, the police may be called, and auditors sometimes face arrest for various charges. Now, usually if a confrontation ensues and the situation escalates. Now, the practice will involve the individual filming their entire encounter with staff and the customers at the public facility, including any escalation, including any argument, including any confrontation. Now, a lot of people don't like to be recorded, even in a public place, and they get upset about it. And also, a lot of people, the police included, often don't know the law around recording people in places in public. So I'm going to talk about the law in Canada, where auditing seems to be a growing phenomenon. I should also note that I'm not a fan of aggressive auditors who really do appear to be looking for a confrontation, likely for the attention, for the clicks, for the views. Now, it's clear to me that the police in the UK have been much better trained about the law around auditors, and there are loads of American resources out there for police training on how to interact with auditors. I'm confident that the police in Canada currently have little training about this at all. Now, before I get into the substance, I'll also emphasize that this is intended to be educational and not legal advice. If you're an auditor or a cop watcher in Canada, you really should have your own lawyer, and they should give you specific advice about your specific activities. Now, people have been shot in the US for doing this, and an aggressive interaction with an armed police officer is inherently a volatile situation. In a nutshell, in Canada, you have the right to take photos and record video in a public place. There's nothing in Canadian criminal law that makes it illegal to take photos or videos in a public place. This right extends to photographing or recording anything visible from a public place, including private property, as long as you are not trespassing. The right is protected under Section 2B of the Canadian Charter of Rights and Freedoms, which guarantees freedom of expression. This includes the right to collect information through photography and videography. And photography and videography are inherently expressive activities. Now, however, this right is not absolute. Now, general laws are always going to apply. You can't create a nuisance, you can't damage property, you can't obstruct traffic, or actually interfere with legitimate police duties. Now, what we often think of as public buildings are a different matter. Private property owners are not subject to the Charter, so the rules that they can implement are largely discretionary. Governments and government agencies are subject to the Charter, and rules that they make, which affect expressive activity, like photography and videography, are subject to Charter scrutiny. I don't think there could be any doubt that the Charter applies to municipalities, provinces, and the federal government. It even applies to school boards and universities. There are loads of cases where individuals and businesses have challenged bylaws and municipal policies for allegedly violating the Charter. In a ban on photography or videography in or near a government building, prima facie violates Section 2B of the Charter of Rights and Freedoms. That section reads, under the heading Fundamental Freedoms, everyone has the following fundamental freedoms: freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Now, we're focused on freedom of expression, and note that includes freedom of the press, but freedom of expression is a right enjoyed by everyone, not just the press. So this question about banning or regulating photography or videography in certain places, this question's been before the courts before. There's actually a series of decisions from Ontario in the late 80s and early 90s called Squires, in which provisions of the Ontario Courts of Justice Act that prohibited photography and videography in and around courthouses was challenged. Now, not surprisingly, it was challenged by the media, but remember that Charter right applies to everyone. In that case, the majority of the Ontario Court of Appeal held, quote, the freedom of expression enjoyed by television journalists, such as the appellant, is the freedom to film events as they occur and to broadcast the film to the public. If television journalists are unable to photograph persons entering or leaving a courtroom, their freedom of expression is curtailed. I agree, therefore, with Justice Taran-Polsky that Section 67 sub 2 sub A sub 2 of the Ontario Courts of Justice Act infringes the freedom of expression conferred on the appellant by Section 2B of the Charter. So here you have the highest court in Ontario saying that it violates Section 2B of the Charter for a law to say where someone can and can't film. But as I'll discuss, this right is not absolute, and it can be subject to reasonable limitations. Now, I should note that assaulting someone with your phone is not Charter protected, but filming them with it is Charter protected. But putting your phone aggressively in someone's face is likely an assault. Now, as I mentioned, the Charter Section 2B can be subject to reasonable limitations. And in order for an infringement of your Section 2B rights to be justified, the framework is under Section 1 of the Charter, applying something called the Oakes test. In order to pass the Oakes test, a restriction has to be prescribed by law. It has to have a pressing and substantial objective. The means chosen by the government actor must be rationally connected to that pressing and substantial objective. 4, it has to impair the affected charter right as little as possible. And 5, there's an ultimate balancing of the positive effects of the government action versus the negative impact on the charter right. And that has to weigh in favor of the government. If the government action fails any of those 5 things, it fails to survive the Section 1 analysis. The blanket bans on photography imposed by the North Bay Police and the Peterborough Police in Ontario, that likely can't be justified. A categorical ban on photography in the publicly accessible areas of police stations may not meet the minimal impairment and overall balancing requirements. It would, in my view, prevent the reporting of newsworthy events and undermine police accountability. I should also note that if someone just puts up a sign that says no photography, no videography, it does not affect anyone who is in a truly public place. The terms of the sign could be enforced against somebody going onto the private property that is subject to those conditions, but slapping a no photography sign on a perimeter fence does not affect or have any power over someone on the outside. You may ask, well, what about privacy laws? You're talking about recording people in public places. Now, the ones I deal with most often regulate what businesses can do. An individual taking photos for personal purposes is not a business. And just to be clear, they also have carve-outs for personal use and artistic use. Here's what PIPEDA says. This part 1 of PIPEDA, does not apply to any individual in respect of personal information that the individual collects, uses, or discloses for personal or domestic purposes, and does not collect, use, or disclose for any other purpose. Or any organization in respect of personal information that the organization collects, uses, or discloses for journalistic, artistic, or literary purposes, and does not collect, use, or disclose for any other purpose. The other provincial general privacy laws have similar exclusions. Now, I could imagine a privacy commissioner saying that a YouTube auditor who makes a living from monetized videos is engaged in commercial activity, so these exceptions don't apply, or they're collecting, using, or disclosing personal information for additional purposes. And my response to that would be that such an interpretation of their privacy laws would be unconstitutional as a violation of Section 2B of the Charter-related right to freedom of expression. The Alberta Privacy Statute was actually found to be unconstitutional because it effectively prohibited union members from recording in a public place, a picket line. If you're in a public place, not actively interfering with someone else's use of the space, it would be hard to call that a true nuisance. Now, it should also be noted that serious interference with someone's lawful enjoyment of the property could also be the criminal code offense of mischief. Now, I think it would have to be pretty serious, and I can't find any cases that have considered public photography as causing such mischief. However, if an auditor were particularly confrontational, I would not be surprised to see the police interpret that as mischief and make an arrest. So what about recording the police from a public or a quasi-public place, or even from within your own property? So let's talk about recording the police in public. In short, there's no law in Canada that prevents a member of the public from taking photographs or video of a police officer executing their duties in public or in a location lawfully controlled by the photographer. Now, I have a full video on the topic that I'll link to below. Now, as we've discussed, people in public places, or people in places that are generally accessible to the public, or people in places that are within public view, they have a reduced expectation of privacy. So you take that and then add on top of that the police, who are public servants working in the course of their employment, they would have a further reduced expectation of privacy, and they would also have a greater expectation of accountability to the police. This is particularly the case with police officers compared to other civil servants, where they're given extraordinary powers, they're given guns, and they're sent out into the streets. There is the critical component, which is their accountability to the public. And if their actions cannot withstand public scrutiny, that's important for the public to know. And yes, you can and you do have a charter-protected right to film and photograph the police in public, but you cannot interfere with or obstruct the lawful actions of a peace officer. So if a police officer is carrying out their lawful duty, and it has to be a lawful duty, and you interfere with that or you obstruct that, you could be charged with and be found guilty of obstruction. But in the vast majority of cases, someone standing on the sidelines with a camera phone, not in the way, would not be obstructing. And they would have a lawful right, a charter-protected right, to record a police officer doing whatever they are doing in public or in view of the public. The court then goes on to talk about the interaction between the police and the public, and particularly the right of the public to take photographs in circumstances like this. The court notes this is applicable across the board. I'm going to read all of paragraph 26 of the decision because it really hits the nail on the head. The court says police-citizen interaction typically involves a significant power imbalance. Just as judges should be hesitant to second-guess police decisions often made under stress, without time for long reflection in back alleys late at night, we have to recognize that the citizen on the other side of that interaction, who may or may not have committed an offense, and who is entitled to the protection of the rule of law, is also often alone in a back alley late at night. The court then says, in the absence of an overarching and tangible safety concern, such as telling a photographer at a fire scene to back away if there's a danger that the building will collapse on him, Telling people not to record these interactions, whether they be a bystander or the person the police are dealing with, is not a lawful exercise of police power. An officer who conducts himself reasonably has nothing to fear from an audio, video, or photographic record of his interaction with the police. The public has a right to use means at their disposal to record their interactions with the police, something that many police services themselves do through in-car cameras and similar technology. The officer's powers exist to allow him to protect the public and himself and to enforce the law. They do not extend to controlling the public record of what happened. The maintenance of that public record plays a significant role in the maintenance of the rule of law. The existence of this form of objective oversight has great potential to minimize abuses of authority and to maintain peaceable interaction between police and the citizenry, all of which is very much in the public interest. Interference by a police officer in the public's exercise of that right is a significant abuse of authority. So let me underline that, a significant abuse of an authority. However, you can't interfere with a police officer's lawful exercise of their duties, but simply standing on the sidelines and taking photos or videos does not typically constitute interference or obstruction. If you're commanded to stop taking photos, that's likely an unlawful command that you do not have to follow, provided you are not interfering with the police. Police cannot force you to unlock your phone or delete photos without a warrant, unless the phone contains evidence of a crime or is seized incident to the arrest. So what's the conclusion here? The issue of auditing public spaces to test the right to record, it's a complex one, balancing freedom of expression with privacy concerns and the lawful duties of authorities. In Canada, the right to take photos and videos in public is constitutionally protected, but it's not absolute. It is subject to limitations such as trespassing laws, criminal laws like voyeurism, nuisance laws, the need to actually avoid interfering with active police legitimate duties. Now, while recording police in public is generally permissible and even encouraged as a form of public accountability, obstructing the police in the course of their duties is not. It's crucial to remember that the law in this area is very fact-specific. And while I hope I provided an educational kind of general overview, this shouldn't be treated as legal advice. Anyone who's involved in these activities should consult with a legal professional to ensure that they are acting within the bounds of the law, and that they know how to assert their rights without escalating the situation, which could cause a pretty unpleasant outcome. So if you've made it to the end here, you're likely someone who should subscribe to this channel. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. There's a bell to get notified of new episodes. Also, you can leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian privacy law. Thanks for tuning in.